Our next speaker is Justin Barks, and he is a commercial intellectual property and entertainment litigator with extensive experience representing the entertainment industry. And it's all about enforcing and defending their rights. He has represented Grammy Award winning artists, global fashion brands, documentary filmmakers, reality television personalities, and more. He's like a rock star in this area. He donates his time pro bono to the Texas Accountants and Lawyers for the Arts and to the University of Houston Law Center. He was named to the annual list of top lawyers in Houston for his entertainment practice each year from 2016 to 2018 and has been named a Texas Rising Star in the fields of entertainment and sports law. So help me to welcome Justin Barks.
I'm Justin Barks. You heard some of the things that I do. I teach. I'm not used to being at a podium, so I apologize if I slide, but I'm going to try and stay still for today. We're talking about copyright. You heard about all sorts of different types of intellectual property with Carlin. You're going to hear some more details about trademarks. I'm just talking about copyright today, and copyright is defined here as an original work of authorship fixed in a tangible medium of expression. Those are all legally important words, which is why I've kind of highlighted them differently. Originality is important. A work of authorship is important. Fixation is important, and fixation in a tangible medium is important. I'm going to walk you through each of these things so you have an understanding kind of at the end of this whether you have a copyright or not. Um, the reality is you are all creating copyrights all the time. There are copyrights that are being created here in this room. I see there's one there, there's another one back there, and there's one right there. You are recording this presentation. We can have a fight over whether you own the underlying work here that I put together, but I made this PowerPoint. I fixed it on my hard drive, right? You're taking pictures of me talking. You are recording and creating a copyright on your phones or tablets, okay? Copyright is all around us. Unfortunately, you're going to learn at the end of this that copyright infringement is also all around us, and we're going to talk about that a little bit. So, originality. We don't really care about whether it's creative or innovative the way that we care about in patent law. Originality is you did something that somebody else didn't do. And because copyright is specifically about the expression of an idea, our expressions are varied. Okay. The photograph taken of me from over in that corner is going to be expressively different and original compared to a photograph taken of me in this corner at the exact same time. That's the level of originality that we're talking about. That slight difference in, lighting and angle. The timing could be a couple seconds later. You got the perfect shot. I'll pose later on if you'd like to do that. But that's what we care about. Okay, and there's this doctrine in the courts that says that we are not, as judges and as lawyers, it's not our job to determine whether or not that originality rises to an amount that's enough to protect. We make an assumption, okay? But those cases where you hear Katy Perry suing Flame or, Led Zeppelin suing Spirit over, the similarities of the songs, they're fighting about originality. They're fighting about somebody made a work that was substantially similar or strikingly similar to their work, okay? So again, doesn't have to be particularly creative, but telephone books, that's not really original. You've taken a bunch of names and phone numbers, you put them in an order that we expect them to be in. If they weren't in the order that they were in, your book would be useless. We wouldn't be able to find the people we wanted to call. Recipe is similar. It's a set of instructions. Recipe books, you'll see a little copyright symbol on a recipe book. That's not because they're lying to you. What they're actually protecting is the images of the delicious food that you're about to try and make look like their delicious food, right? And maybe you'll see on these recipe pages, blogs that you find online, there's a whole lot of prose before you get to the actual recipe. right? That's the stuff that's being protected. It's not the recipes, the instructions themselves. Okay. And then we know about the public domain. We're going to talk about how things enter the public domain later on, but the public domain is that bargain that we have in the US Constitution that says that we're going to protect these creative, authorial, fixed works for a period of time. And then once that's over, anybody can use them. Okay. Same thing with patents. When the patent protection expires, you can use them, right? And Shirazi is going to get up here and tell you about how trademarks is wildly different than that. So keep your ears open for that. So that's originality. The next thing is authorship, like a work of authorship. This is where we talk about AI. Until probably 5 years ago, we were really just talking about monkeys and elephants. Works of authorship, you've maybe been to a zoo or a circus where they hand a paintbrush to an elephant and it dips the, paintbrush in a bunch of paint and makes a beautiful painting by an elephant, right? And somebody's trained that elephant to do that. Somebody might have directed the elephant on what specifically to paint, but because the elephant isn't a human, there is no copyright in that image. Okay. There's a very famous case of a monkey who was given a camera and took a selfie of himself. He was very cute. The man who found the monkey, handed him the camera, tried to claim copyright over this. PETA got involved. They said monkeys should have rights and copyright. The court said, no, monkeys have no rights, and this man also doesn't have any rights. The excellent photograph goes straight into the public domain. Okay, so that was 5 years ago. We talked about, in the context of authorship, we talked about monkeys regularly. Now we're talking about AI. AI is also, as we know, not human. Especially our large language models. They collect a massive amount of information, tie a lot of that information, including video, audio, and still images, to certain words. And when you type those words together, the AI tries to build something that makes sense to us based on the words that we've tied to it. That is not human. And there have been a number of cases that have gone to the Copyright Office and then to the appeals, the Copyright Review Board, the appeal, where those copyrights have been refused because there isn't human authorship. A couple of months ago, the Copyright Office was asked by Congress to produce a study on how to deal with these. As Carlin aptly noted, this is changing constantly. It took the Copyright Office nearly a year to come up with their complete policy study. And in that time, I think Midjourney, which is one of the image generator large language models, had been iterated like 5 or 6 times, right? And I'll take questions at the very end. So that gives you an idea, and we're not even making law on that. That's just a, hey, so do you have any ideas on what we do? Well, the Copyright Office says, they say, we will look at protecting AI as long as there is substantial human involvement. So even though we're past the monkeys and elephants, we're still looking at substantial human involvement, and anything that you use an AI for needs to be disclaimed. Your prompts don't count. You theoretically could take an image, a bunch of your own images, and put them together, and then repaint over them or something like that, and create a protectable work. But for the most part, it's not going to work for you. I would wait until the law is very clear before you start asserting copyrights against other people when you use AI to make them. All right, so we're going to talk about the list of protectable works that fall under the Copyright Act in the next slide. But it's also important to note that we're all in this room. I say human. There's a little margin there, right? Human can also mean person, and person in the law can mean company. So a group of people, essentially, right? And so an author doesn't necessarily have to be, you or you or you. It can also be the company that you all got together and made in order to make these authorial works. We'll talk about some of the differences between humans and company humans later on as well. Okay, so here's the types of works of authorship, and I'm not going to go through them, but I'm going to note for you that you don't see things like, football playbooks, software, right? CAD drawings. You don't see those there. It's not because we don't protect them, but we have to fit our copyright protections within those categories that are prescribed by Congress. So, as an example, with software, you may have visual components in the software that you need to protect through what we call the pictorial, graphic, and sculptural works protection of work of visual art. Or if you're protecting the code, right? And it's original code to you, we would tend to protect that as a literary work. Seems confusing, but that's what we're trying to mangle and mush copyright into. What I'm doing right now, for those of you who are not recording me, I don't own a copyright over the words that I'm speaking to you. Okay. Part of that reason is because I'm not fixing them, right? An oral presentation is not fixed in any sort of tangible medium. The reason why copyright's being created right now by those of you in the audience who are recording me is because it's being fixed onto your phone or your tablet. Okay. Yoga poses aren't going to fall into this. And people have tried to, for instance, characterize them as choreographic works. Um, that delves into an area called functionality because there's only so many yoga poses and positions. We don't protect those because they all kind of merge. And what we really want is to protect expression and creativity, and we don't want to stop people from doing things that are going to kind of benefit humanity largely. Right? Okay, moving on to okay, our rights. Okay, so copyright is not simply like the right to make copies, although that is one of the more important things. Each of you who is recording me right now, you are infringing on my copyright to this PowerPoint. You're making copies. I'm going to go out and sue you. That's not true. But that's the first right, okay? The second is distribution. Now, you've made your copies, and I'm going to grant you a license right now. We can grant an oral license to a copyright, and I'm giving you the license to make this copy, but I don't grant you a license to distribute any of these copies that you're making. Each of these rights can be split up and carved up and divided and sent to other people, okay? So making copies, distributing copies, public performance and display, and creation of derivative works. We could turn this into a musical. I think it would be fantastic. I'll be inviting investment after the program. And then the last is transmission of sound recordings. Carlin mentioned that the law takes a long time to catch up. The internet and digital sound recordings had been kind of in progress for a very long time, and it wasn't until the turn of the millennium that we finally added this concept that you could stream music or transmit sound recordings digitally. In fact, it wasn't until 1972 that sound recordings themselves were protected under the Copyright Act in the United States. So it takes a long time. All right. Okay. So I highlighted way back here. Okay. Way back here. Owner, right? Okay. We mentioned humans. We mentioned companies. I want to talk about that a little bit. Like Carlin mentioned, the owner of a patent is the inventor, but it's different in different forms of intellectual property. In copyright law, we talk about the kind of equivalent of an inventor is an author. Okay. Remember works of authorship. You are an author, then the copyright vests in you upon fixation. Okay. However, there can be some hiccups. You and your buddy, right? You're maybe working on a story together or a novel, or maybe you're recording some music together. You can have more than one author, and more than one author is going to have all of these rights. Okay. And just like in the patent law, each of those rights can be exploited by each of those authors, not to each other's exclusion, but all of them. We call it joint undivided ownership. Okay. 100% undivided interest in the copyright. Everybody can make copies, everybody can distribute. How do you know you've made a joint work? Well, you have this subjective and objective test, which is simply, uh, do I think that you wanted to make a work with me? And is there something to indicate that we actually intended to put independently copyright protectable elements together, right? Did you bring Mary Had a Little Lamb to our remix, and that's in the public domain and that's not protectable, right? And I produced, a bunch of really creative raps over Mary Had a Little Lamb. That's not something I can do. I don't know why I came up with that. But if I contribute something authorial and you contribute something from the public domain, that's not joint authorship. We have to come together and make something, each of us bringing something original and expressive. Okay. These guys, the authors, they're always the original owners. Okay. And we'll talk about kind of transfer in a minute. However, um, owners can change, okay, in a couple of different ways through employment. So if part of your job, let's say you work for an architectural firm, part of your job is to draw, architectural works for a firm, okay? Those are probably not owned by you. Say you're in the marketing division of, an oil and gas services company and you're making a bunch of marketing collateral. um, the images and the copy that you're writing is probably not owned by you, that's owned by the company. Okay. And so the owner is not in that instance the author, because you have an employment relationship and a contract relationship that says, hey, employer, my job is to do these things for your benefit. Therefore, you own the copyright. Similarly, if these two joint authors get together and they've made a song, and a record label says we want to release this song and exploit it, um, they can get together and they can transfer or assign those rights to the record label, because the record label is going to do a much better job of releasing and exploiting the record. Ideally, they're going to get some money off of it that they wouldn't have normally gotten. That's where the literary publishing industry comes from, the film and television industry, the music industry, etc. Okay. Um, Again, things get complicated when you divide up ownership of a single work. As Carlin mentioned in patent law as well. So how long does my protection last? Um, my protection lasts different times, different lengths, depending on whether the author is a human or a kind of juristic person, like a company. Okay. So if the author is a person, then we talk about it in terms of the life of the author. There's two or more authors, it's the life of the last living author. And then we tack on an additional 70 years after that. Okay. The idea is that during your lifetime, you may be a genius and nobody knew who you were. And then when you die, we're all sad. And then we discover your archives, and then your heirs get to make all the money off of your work. That's kind of the idea. Um, I don't know that that works in practice so much these days, but it has historically. Um, if the author is a company or a commissioner, so similar to the contract idea where you're making something for me through either a work for hire contract or a commission agreement, or through an employer relationship, the term is not calculated based on the life of a person, because companies can live forever technically, right? So we have to have some other way of doing that, and we do that based on something called publication. There was a question, I'm going to divert a little bit. You had a question about Autodesk and publication, and I just want to put a point on the difference between patent and copyright law for this purpose. You could theoretically be, you know, um, you could be publishing pursuant to the patent laws, by sharing your inventiveness, your original kind of novel ideas in one of those settings. I don't think the Autodesk cloud setting actually works, but for copyright law, that's not what we care about. In copyright law, we care about, I have it right there at the bottom. You might not be able to read it because I put it at the very bottom. Publication has a different definition. We care about whether you've sold, rented, or leased um, the work. Okay. So you might have a website, right? You took a bunch of pictures and you put it on the website. And it's not so that you can sell those pictures, but because you have a blog, right? But you want to protect all those pictures. You're not offering those images on your blog for sale or lease or assignment or lending, right? And so even though the public can view those images, they're not considered published, which is kind of there's some cognitive dissonance there, because they're out in the world, anybody can see them. Theoretically, somebody could come right click and save as, and they've infringed your copyright by making a copy. But for the purpose of the Copyright Act, we care about this kind of commercial exploitation. Okay. And so when we're talking about companies or commissioners, the term of a copyright is defined by either publication. Okay. So if it's published, then the term expires 95 years after publication. If it's unpublished, then it's 120 years after the date of creation. If you wait until 75 years after somebody's made your corporate or commissioned work to publish it, then you've lost the 120 years. We go to the shorter length of time, the shorter term. Okay. Once the term ends, all is not lost, uh, unless you're trying to exploit and commercialize the work, because now it's in the public domain, everybody can use it. Oftentimes that breathes new life into works, and kind of the authorial notoriety increases, right? So right now we look at works on Public Domain Day, which is January 1st of every year. I think we're looking at works from 1927 and earlier generally are in the public domain. Don't use that as legal advice because it does depend on the type of work, but that's generally it. Okay, now we can register. So in patent land, you have to get a granted patent in order to have all of the authority and power of the United States government to protect your monopoly. In copyright land, we don't. It used to be the case that we did, but we signed on to an international treaty called the Berne Convention, and we adopted this idea that copyright vests in the author upon fixation. So when I say that y'all right now, I mean, boom, 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 boom. There's I don't know, 10 copyrights being made right now. It's happening right now. Okay. Why would I need to register if you're telling me, Justin, that I have copyrights as soon as I save this thing to my phone? Well, the reason is we're trying to incentivize you to, number one, add stuff to our big national library called the Library of Congress. And number two, we want to make sure that there is a record of all these copyrights that are created, right? The kind of utilitarian bargain in the Constitution says that we will promote progress of the useful arts and sciences. How do we do that if we don't know that you're making new stuff? So register it. So what they do is they say you can't sue anybody if you don't register. If you register, then your work is of public record. Anybody can look you up and find out that you've made this cool work. You have a presumption of validity of your copyright, so you don't have to prove that you made it when you made it. A lot of people think about that in the context of, right down here, poor man's copyright, right? I'm going to mail it to myself. I'm going to post it on social media. And since I posted on social media, I know this is a new one for me. It was always, I'm going to mail it to myself. And then a couple weeks ago, somebody said, well, because I posted it on social media, that means I don't have to have a registration, right? No, 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 no. Now it's out there and anybody can get it, and they can take your stuff. So definitely register so you can enforce your rights. So those presumptions and the ability to sue, that only comes from the registration. And we want to extra incentivize you to register those things quickly. And we do that by saying you don't get your statutory damages, attorney's fees, or costs if you don't register the work with the Copyright Office within 3 months of publication or before the infringement occurs, right? So those of you who are thinking, oh, well, I put my pictures up on Instagram, so if somebody takes them, we can go back and see that I was the first one, or my pictures first. That doesn't fix anything. Statutory damages are a remedy election, so you can have to prove, normally, you'd have to prove what your actual injury was from somebody stealing your post on Instagram and reposting it. Probably there's not a lot of monetary value there. But statutory damages say that because it's difficult often to prove what that monetary value is, we can elect within a range. And that range can be from $200 for an innocent infringement. Somebody just didn't know, they weren't aware that you owned it, all the way up to $150,000 per work infringed if it was willful. Okay. That's why you hear all these copyright suits for millions and millions of dollars. They're claiming willfulness. Okay. All right. So how do you register? Easy, easy, easy. You go to copyright.gov. This whole system, patents are very complicated. That's the reason why the USPTO requires people pass a specific test to become patent attorneys and patent agents. Copyright, really, we're trying to make it as easy as possible. Compared to patents, this is very, very inexpensive. Often, I have a $45 up there. That's for a one work, one author application, as long as the author is a human being. So if you write some poetry and you want to protect your poetry, you go to the Copyright Office's website, you create an account, and you pay $45 and fill out their questions, send them a copy of your Word document of the poem, and they're going to send you a copyright registration. It's that easy. It is not complicated. The fees can vary. Those of you who are photographers, they can go all the way up to $120 for a series of photographs. You can register up to 700 at a time. Those of you in the music business, you can pay an $85 fee for something called a gram, which allows you to register both sound recordings and music with multiple joint authors in them. The fee schedules may change. They have not changed much in the way of like an upward trajectory, although we've seen a lot of increases in trademark and patent fees over the years. I would expect some of these to shift as well, although they really are trying to get just the average person to be able to do this. So check out the fees there. That's where that link will take you to the fee schedule. There's a bunch of tutorials. So if what I just explained to you just absolutely sounds way too foreign and you're not going to be able to do it on your own, fine. They have these great videos that'll walk you through exactly how to fill out these forms and put in the information correctly. You'll be able to understand the difference between the rights and permissions and the limitations and all this stuff in the application. It's not scary. If you need help, you can always come to the University of Houston Entertainment Law Clinic and we'll do this stuff for free. And then if you're really into copyright, you can go to this copyright.gov/circs, and there's a series of circulars that will dive even deeper into different parts of copyright law than we've talked about here. And they're really great. They're put on by the Copyright Office's education section. And they give you links to call up a librarian at the Library of Congress if you have questions. So they're fantastic. Okay, and that's it for me. We don't have a whole lot of time for questions, but 10 minutes. Do we have the microphone?
I have a scenario. Let's say you are a brick and mortar food and beverage company and you want to hire an advertising agency. Once you hire them to create content like reels and other collateral, how do you protect your work from the agency in this scenario?
So you're doing stuff and you hire an advertising agency. They're going to take your work and they're going to add to it.
Yeah, maybe they can repurpose it, or how can you protect your work from being repurposed from the advertising agency?
Contract. Contract. So if I understand your question correctly, whether you're if you're handing over some of your work to an advertising agency, you're going to always have some sort of agreement to hire them, right? And in that contract, there's going to be language that distinguishes between work that they make that they're going to own and work that you make and give to them that you own. Okay. Oftentimes, what I try to do with my clients is negotiate that the work product that's delivered becomes mine because I paid you to do it. So it's that work for hire kind of commissioned relationship. If we somehow get sideways and I don't pay you, or you create some work product that I reject, all of that work product that I didn't pay for and didn't accept and wasn't considered delivered, that would be theirs that they get to keep. But all of the stuff that I bring to the table is mine. You can't take it and use it at all. And anything that you make for me that I pay for and that's delivered that we use, that's also mine.
Thank you.
Yeah.
As a follow-up question, let's say you have employees in your business and they are part of that content. How do you protect yourself as a business owner from, I don't know what is it called exactly, but employees complaining about you in the future, use them in the public domain or social media? Waiver?
So I'm sensing that there's a non-copyright question in there. If it's employees who actually make the work, then if they appear in the work,
The work.
okay, it would be an appearance waiver and release.
Appearance waiver.
Mhm.
Thank you.
Yeah. Anybody else? Yeah. I didn't direct anything to you. I apologize.
That's okay. I'm
Okay.
just in the side pocket. My question is concerning logos. let's hypothetically say I'm starting the Henderson Chess Club and I want to remove that eagle off that HCC and maintain the swoop, but put a king or a queen chess piece there.
Yeah.
Is that copyright infringement?
No, but Shiro's going to tell you not to do it. This lovely lady right here is going to tell you, please, please don't. So it's not copyright infringement for the reason that a lot of logos don't reach the level of kind of originality that would be necessary to protect them under copyright. Fonts, for instance, don't count. And this HCC font is unique and it's got the swoop with the eagle in it and stuff. That's not on its own protectable. And a clip art of a chess piece probably like there's a merger there, right? There's only a certain number of ways that you can produce each of those chess pieces in a two-dimensional way. And so I think you would probably get a rejection from the Copyright Office on that copyright application if that's all it was. You would also get sued by HCC, and Shiro's gonna tell you why. Unless you got a license, obviously. Yeah. But it's a fantastic question. Logos, you can get trademarks and copyrights for logos. It has whether you can do both tends to have more to do with what is the kind of creative expressive content in the logo that's being protected independent from the kind of source communication part of the logo. That's a good question. Yeah. Let's keep going. I answered all the questions live.
Oh, you just answered my
Oh,
question. so-
fantastic. That's great. There's one right in the back.
I'm not exactly sure if this is a copyright or trademark, but how do we protect our personhood? Meaning when someone takes a photo of you and they decide to manipulate it in a way that you're doing something that you never think of doing, which is happening all over the internet. This may not be the right forum, but I just wanted to know, does that even go into copyright
Are
and
you
protecting your personhood?
are you going to talk about right of publicity?
I'm sorry.
Is Shirazi, you're going to talk about right of publicity? Okay, so you're that is a body of law that is a very kind of special body of law. In fact, Texas has some of the first case law regarding the right of publicity in the country, and we're trying to figure out how to deal with that in the context of what's been called NIL these days. The jurisdiction that's really kind of pushing the boundaries is in Tennessee. They just passed the Elvis Act, which added to their right of publicity, statutory right of publicity protections, the ability to limit the voice and kind of pictorial image of a person. You should know that for the most part, right of publicity ends up being a part of privacy law. We think about right of publicity as saying you can't invade my space commercially, similar to you can't invade my space, privately. You can't paint me in a false light. You can't you can't defame me, etc. So most people, the average person, doesn't have commercial value in their name, image, and likeness, was just going to limit the ability for you to sue under that theory. But invasion of privacy is always a matter of state law. Most states have adopted some version of a false light or invasion of privacy statute. And if not, there's typically some sort of common law theory where it's judge-made law. And that's the direction that I would take it. It's not copyright. It's closer related to trademark law. But it's, I wouldn't worry too much about it. There's a lot being made of it in the news, especially with all the AI and deepfake stuff. But most of us are not really targets to that sort of stuff. Yeah. One more? Can we do one more, Mark?
You mentioned the U of H law clinic or something. Can you tell us more about that, please?
Sure. So I'm the director of the University of Houston Law Center across town has a number of law clinics, including a trademarks clinic, an entertainment law clinic, a civil rights clinic, etc. South Texas College of Law also has a trademarks clinic. And what the entertainment law clinic that I direct kind of differs from the trademarks clinic is that we also do a lot of these contracts, some of the appearance releases that you're talking about, copyright licensing and assignments, as well as each semester we have a copyright registration day where we invite folks from the community to come in and sit with our student attorneys for about 30 minutes, get some copyrights filed, and go on. So you can come to us. I can share, I guess, a link to that with Maya, and you can always sign up for our intake form where we can reach out to you and the students will connect with you. Or what I can also do is I'll make sure that HCC gets our kind of flyer for the fall semester's copyright registration clinic, and then you can sign up for either virtual or in-person appointments at that time. What we typically do for direct clients, there's a $100 administration fee, depending on the type of work that we're doing. For copyright registration day, the only thing that you need to show up and pay for is the actual cost of the registration itself. So it's a really nice deal. Okay. Yeah. Thank you. Thanks, guys.